My Lords, I'm going to confine my engagement with this bill and my remarks to whistleblowing protection and to NDAs, and I intend to bring forward amendments in these areas, as well as hopefully joining on amendments by others, especially Lord Wills, and I hope very much Baroness Morrissey, my colleague in the other place, Leila Moran, brought forward the NDA sexual harassment amendment in the other place. My Lords, I've long argued that existing protection for whistleblowers under the Public Interest Disclosure Act of 1999, PIDA for short, is wholly inadequate. The inadequacy is in part because PIDA is drafted as employment law, limiting the remedies to workers and seeking redress through an employment tribunal. And that's a great injustice to the many whistleblowers that in law the term whistleblower is restricted only to those categorised as workers. In contrast, and somewhat confusing matters, this House will know that HMRC has recently relaunched a significantly improved whistleblower reward scheme which invites any citizen with evidence of fraud to come forward as a whistleblower. HMRC is not alone. The CMA has a long-standing incentivised scheme for citizen whistleblowers, and now the Serious Fraud Office is also looking to incentivise citizen whistleblowers. My Lord, all of this, in a sense, we've got the enforcement agencies freelancing to try and deal with the problems in PIDA, but it gives us an opportunity, I think, to redesign the whistleblowing framework and remove the barriers that PIDA, I'm sure unintentionally, originally created. But the problems go well beyond just who is covered by PIDA, a law that few, even lawyers, really understand, as demonstrated by the alarmingly low rate of whistleblower cases that succeed in employment tribunal. About 4% of those that are brought on people who are recognised, acknowledged by everyone in the room to be whistleblowers, but they can't carry their cases through. The employment tribunal process is tortuous. It pits a whistleblower with limited resources, limited knowledge, and little, if any, legal assistance, even when there's trade union support, against an organisation with often unlimited resources and expert legal counsel. It exhausts and impoverishes whistleblowers by allowing cases to be dragged out for years. It requires the whistleblower to provide conclusive evidence to prove that they were dismissed because of whistleblowing. And the tribunal is not concerned in any way to see that the wrongdoing identified by a whistleblower is investigated. The entire system is set up to encourage whistleblowers to settle their case, and more often than not, they have no choice but to sign settlements containing non-disclosure agreements. They're known in the UK as confidentiality clauses. The NDA acts as a tool to enforce silence and suppress evidence of harm to the public. And we've heard how in sexual harassment cases it plays that key role. Among amendments I will bring, I intend to include an office of the whistleblower structured as a hub to work with regulators and enforcement. It will be a place where whistleblowers can confidentially and anonymously deposit information and evidence of wrongdoing without fear of retaliation. It will be in a position to identify significant patterns of wrongdoing, such as the Post Office Horizon scandal. It would have helped so much in sexual harassment cases by making sure they were pulled together and visible in one place. It will have the power to impose remedies and compensation where whistleblowers suffer detriment. Now, I prefer it to sit under the Cabinet Office, but I've probably got no choice but to put it under Trade and Industry. My Lords, I know I'm going slightly over time, so let me just say this. I'm also supporting the duty of candour, and the folks behind that move, which is crucial, are also supporting the office of the whistleblower.
Hear, hear.